Welcome, bienvenue. It's the most wonderful time of the year. And I'm not a masochist, so I'm not talking about the holiday run up, and I'm not talking about pandemic spikes or the almost permanent midnight here that we have in the Northern Hemisphere, and in particular in The Hague today. I'm talking about the ADC annual conference, and I'm thrilled that we can all be here today because it almost didn't happen again, but here we are. And I'm Marie O'Leary. I am the current president of the ADC-ICT, and I have been serving this year with an incredible executive council committee and with a real outside of the box training committee. And we all started 2021 blissfully unaware that the end of this year would be so pandemic dramatic. We all blindly said, let's try an in-person conference. But after all, this is the 19th year of the ADC. And the annual conference has been something that I know that I appreciate, and we go into year after year. We get to see each other, we get to talk about things, and we missed it last year. And this specific conference was way too good to sit on a shelf. It could not sit there and wait to discuss for another year. So we moved it here online, where we have all of you here. Because we're spending this 21st year of this 21st century in this non-ending pandemic, we have to be online. But at the same time, we get to have people from all over the world right now. We've actually got to expand the base of the conference, so we will be able to have ideas and thoughts of people in far-flung lands, in far-flung time zones from where we usually congregate here in the, which is fantastic. But we also have the opportunity to reach out to each other and finally discuss some of these things that have been on our minds, and to really contact each other, connect, and say to each other, you know, I think that decision really was decided wrong, and here's my opinion why. But truly, we're far overdue to come together on this and these significant issues today, in particular, fairness and international criminal justice. Reality or utopia? Fairness, what does it require? What are the pressure points of fairness? What can be done? And in this age of truthiness, how do we ensure that truth is truth and fair is fair? And I know I have a lot of thoughts on this hot topic, these hot topics that we're going to discuss today. And I know all of you do too. But we have a truly incredible lineup of panelists and moderators who are going to take us on this journey, guide us through these conversations, so we can all get to the true answers of what is fair and how do we do it. But before we jump in, I want to guide you through the day a little bit as far as online, how are we going to do this? First of all, we have 3 panels today. And as always, if you can keep the microphones off, if you're not speaking, that would be best for all of us, because we don't actually need the background noise to add any ambiance to the day. If you would like to intervene, you have a question in the course of the panel, just use your little electronic hand raise or type your question into the chat. If you want to find the little hand, they've now moved it into Zoom. If you go under reactions, so click on the 3 dots on the bottom where it says more. From that, you can see there's something called reactions, which allows all sorts of emojis, but it also allows you to put your hand up. For anyone unfamiliar, there's my hand up, and that's what it looks like. In the same place, you can actually go ahead and lower your hand, as I just have now. That will let us know, and let the moderator know in particular, that you would like to take the floor with a question. When you are called on, you can take the floor, you can put your camera on, you can put your mic on, and you can ask that question to the panel. But please wait until you're called upon. Otherwise, we have a lot of people here and it could get a little overlap. In between the panels, we're going to try something new, because we were talking about the one thing we really miss about the conference, other than the great wisdom brought by the panels, is going into coffee and saying, hey, I haven't seen you in a while, or continuing that discussion that we've had just now on the panel. So we're offering 3 breakout rooms in between. It'll be the entirety of the first break, coffee break that we have in the morning, and the last half hour of the lunch break between 2 and 2:30. There will be 3 breakout rooms. Again, go to those 3 dots down there. Don't go there now, but you'll see where it says breakout rooms. That's where you'll be able to join a breakout room at the correct time. The topics that'll be there are continuing the panel discussion, general coffee talk or networking, And just feel free to go into those and see who you meet. They're not recorded, they're just for discussion. And we'll see, if people are interested. Totally optional, just giving a space for you to talk about things on the coffee break, especially if you're sitting there and you don't want to bother your housemates or pets with thought that you had from the last panel. If they're really successful, who knows, in the future or even today, maybe we could add a few more to the afternoon session. The hot topics that we normally talk about over coffee, such as the weather, why are politics so weird now, and what is TikTok? But for now, get comfortable. I can see you already are. It's a wonderful location that we've set up for today. Grab a pencil, paper, notepad, computer, whatever, to take some notes and write some questions down. And without further ado, I will hand over to our first panel and the skilled moderator of Marianne Carin, who will usher us into the day with the first topic. So I hand over to the panel and to you, Marianne. Thank you.
Well, thank you very much, Marie. I hope everyone hears me correctly. I'm gonna put my telephone in silent mode. And so good morning to all of you, and thank you for joining us to this conference, especially you early birds who have decided to attend the first panel. My name is Marion Carin. As you can hear from my accent, I'm French, and I have the privilege to be your moderator for the next 1.5 hours. Without further ado, please allow me to introduce our wonderful panelists, starting with Kate Gibson, that you can see probably on the gallery next to me. Kate is an Australian lawyer. She's been practicing before international courts and tribunals since 2005, and she has appeared before the ICC, the ICTR, the IRMCT, the ACCC, and the SCSL. Currently, Kate is co-counsel for Bosco and Ntaganda before the ICC, and she also represents Rohingya victims in the Bangladesh-Myanmar situation. Kate also leads the legal team of Paul Rusesabagina, who is charged with terrorism in Rwanda, and she is a member of the defense team of former president of Kosovo, Hashim Thaçi, before the Kosovo Specialist Chambers. Previously at the ICC, Kate was the co-counsel for Jean-Pierre Bemba, and you have probably heard of this case, who finished with an acquittal in 2018. Her prominent work extends to human rights and also transitional justice. And to finish, I have the privilege to call her my friend. Next, Stéphane Bourgon, that I have known for quite a while too. Stéphane is an international criminal defense attorney registered at the Quebec Bar. He's been practicing before international courts and tribunals for decades. You all know him. And in addition, he has a sound experience as a criminal attorney in Quebec, notably within the Canadian Forced Arms, as what you call in Canada a JAG. Initially, he joined the Office of the Prosecutor of the ACTY in 1998 before being appointed as chef de cabinet for the president of the tribunal, who was the French judge, Claude Jorda. He then represented accused before the ACTY, including the General Enver Hadjiasanovic. And he is currently lead counsel for Bosco and Ntaganda before the ICC. Has been lead counsel for Alfred Yeketom and for Maximilien Turinabo before the IRMCT. And our last panelist is Kairan Mohandas Menon. He is currently a Hardeman doctoral scholar at the Irish Centre for Human Rights and a legal fellow with the Guernica Centre for International Justice. From 2017 to 2021, he worked with the International Nuremberg Principal Academy. He has also worked on international law and justice related issues in India, Greece, and Spain. So as you can see, I am very well accompanied for this panel. Our topic for today is, can politics influence fair trials? And you know, this is a vast and highly contentious subject. I had prepared a personal anecdote to start with, But now that I'm thinking about it, I think that none of this will be as relevant as our panelist interventions. And that's why I would like to start by giving the floor to our first panelist, and I guess it will be Kate. Kate, is it you who starts? Yes. So Kate, please, we cannot wait to hear you.
Thank you very much, Marion. I'm happy to go first. It's 4 in the morning where Stefan is joining us from, so I think it's only fair that I kick things off. Hello, everybody. It's really nice to be here with you so early on a Saturday. I love the ADC, so I was so pleased to have been asked to be part of this panel and to speak alongside these colleagues and friends that I really admire. The question that we've been asked to consider today: can politics influence the fairness of trials? Yes, is the answer. Simple answer, yes, it can. Political agendas, political interference, political manipulation, of course, has the ability to turn a fair trial into an unfair one. And this is not just a defence position. This is not some controversial outlier defence viewpoint. Prosecutors talk about this. At the ICTY, the former prosecutor Carla Del Ponte was open about the fact that she thought political interference had really inhibited her work, from states, harbouring fugitives to interfering with witnesses. At the ICC, when the prosecutor Fatou Bensouda withdrew the charges in the Kenyan cases, she said this is because of political interference. The interference in politics means that I can't get the witnesses to cooperate with me in this trial. Normally, what we hear from international prosecutors is different. We hear politics and justice are separate. Prosecutors, we don't respond to political pressure. We're free from political influence. But the fundamental reality is, if you put that narrative aside, the mechanics of international justice, its actual functioning on the ground, the investigations, the witnesses, the access, the courtrooms, the evidence, all of that depends on cooperation from political actors. And when jurisdiction is essentially consensual, as it is at the ICC, it's just not possible to divorce justice from political agendas, where states like the US can put sanctions on the prosecutor, where defense counsel can be blocked from entering the territory of a crime base. Political whims of states dictate what we can do. And the question then becomes, for today's purposes, does that make the trials unfair? Do the political forces at play lead to unfair trials? I don't think political leaders pick up the phone to judges and say, this is how you should decide this case, or pick up the phone to prosecutors and say, this is how you should prosecute this case. But we have examples that we can't ignore of overt political pressure from states' parties and from states, putting obstacles in the way of international courts and tribunals when they're not happy with the way that things are progressing. So today, what I wanted to do was just give you some concrete examples of how politics is weighed in and, I think, impacted on the fairness of the trials that I've been involved in. So I was going to start with the Bemba case, although it seems really early in the morning to be talking about the Bemba case. But, and also you might be thinking, what am I complaining about? He got acquitted. But in reality, the political interference in that trial was staggering. We couldn't go to the Central African Republic. The defense team never went to the site of the crime base. we couldn't safely conduct investigations in country. So the prosecution is welcomed into the Central African Republic again and again and again, and we couldn't go. The significance of that was that we were examining witnesses blind. You know, in cases I've been involved in Rwanda and in Cambodia, you know every inch of your sites. You know if a witness is standing in this compound, they can't see what's happening on that hill. You know the dimensions of every prison cell in a prison in Phnom Penh. On the Bemba case, we hadn't been there. We hadn't seen the sites, smelt the air, seen the vegetation. What do the buildings like? What do the houses look like? Is it possible for Bemba to have landed a plane there where the prosecution says that he landed a plane? We couldn't see those things. And that's a huge disadvantage to us. And that impacts on the right of the accused to adequate resources to prepare his defense. But more than that, Mr. Bemba's troops, who were the alleged perpetrators of the crime, were a very small part, about 10%, of a much larger contingent of troops that was actually made up of 7 different armed groups, one of which was the Central African Army, which is now supporting the regime in power in the Central African Republic. And all these 7 different armed groups were wearing the same uniform and were visually indistinguishable. Of the thousands and thousands of pages of disclosure from the prosecution, there was no indication that anyone other than Mr. Bemba's fragment of that troops was committing any other kinds of infractions. No one else was committing crimes on either side. And not only is that inherently implausible, we know that it wasn't true because, human rights reporting at the time told us that it was untrue. And the prosecution aren't bad at their jobs. They know how to investigate. So why is it, after years and years of investigation, the prosecution didn't disclose a single document that indicated in any way that anyone other than Mr. Bemba's troops were committing crimes? That's political. That's interference. That affects the fairness of the trial. A complete lack of exonerating evidence. The prosecution isn't fulfilling its statutory duty to investigate incriminating and exonerating circumstances equally. It's conducting a one-sided investigation to collect evidence in order to be able to maintain its access to the territory that is controlled by the political and military adversary of Mr. Bemba, who wouldn't give us access. And then Mr. Bemba is acquitted in 2018 due to errors by the trial chamber in the assessment of evidence. And what's really interesting in terms of political interference was the reaction of the state's parties to that acquittal. The fallout from the Bemba appeals judgment was, horrific, frankly. It was very overwhelming. For me personally, it was too much to cope with, the attacks on Mr. Bemba, the attacks on the lawyers. But to give you one concrete example, the ICC's largest financial contributor is Japan. In 2019, Japan contributed 261 million euros to the operating budget of the court. And at the first Assembly of States parties, after Mr. Bemba's acquittal, the representative from the government of Japan got up and said the following, and these are real quotes, and you can read the speech, it's online. He said Japan was deeply concerned about ICC accused being acquitted because acquittals indicate the challenges we face in the collection and evaluation of evidence and performance in trials. And if acquittals are allowed to continue, justice cannot be brought to the international community. And he urged the ICC to take steps to prevent such unusual circumstances from happening again, and then made reference to the 261 million euros. It's not reading very far between the lines to get to, if you keep acquitting people, we're going to stop funding you. He said, if you keep acquitting people, then justice won't be served. What does that feel like for a new accused who turns up at the ICC? Does he think he's going to get a fair shake? Or is everything stacked against him? Will an accused feel like they're arriving at this sort of neutral temple of justice? Or will they feel that they're at a political institution? The ICC isn't alone here. I did 3 cases at the ICTR, 2 of which ended in acquittals. And the reaction of the Rwandan government to those acquittals was, sort of naked outrage. When my client, Justin McGenzie, was acquitted after 13 years in prison, 13 years, and then an acquittal, we should have a whole other panel on that. But after he was acquitted, the Rwandan government came out, and the prosecutor general, Martin Ngoga, said, and I looked this up last night actually, and it wasn't as bad as I'd remembered, but it's still pretty bad. He said, this is an extremely disappointing decision by the appeals chamber of the ICTR. Tribunals' decisions such as these are undermining its legacy. It's not ideal. Putting those statements from the government aside, there was a much more sort of sinister and pervasive aspect of political pressure at the ICTR, which was the obstacles that we faced every day in trying to get witnesses in Rwanda to cooperate with us. And not even to testify, but just to meet with us and talk to us on the defence. An accused has the right under the ICTR statute, and indeed ICCPR Article 14 has a right to be able to obtain the attendance and examination of witnesses on their behalf under the same conditions as the witnesses against them. That's a central component of a fair trial. There are only 10 fair trial rights guaranteed under the statute, and that's one of them. And so it's sort of up there, with presumption of innocence and the right to know the charges. We had no way of calling Rwandan witnesses before the ICTR without going through the ICTR Victim and Witness Unit, who in turn went through the Ministry of Justice, who in turn went through, for a reason I never understood, the Ministry of Foreign Affairs in Rwanda. So you could not testify in front of the ICTR as a defence witness without it being known to the government. And when I was co-counsel for the former bourgmestre of Murambi commune, Jean-Baptiste Gatete, he had been accused on the 7th of April, on the first morning of the genocide, of murdering a very prominent local Tutsi leader. The prosecution's case was that he went with sort of hundreds of Interahamwe wielding machetes to her compound, went in, and he killed her in front of her kids and her husband, and then he took her body and put it in the back of the communal vehicle, this Toyota, and drove around town with it. A horrific allegation. And I was in Rwanda trying to find out more about, the killing of this woman who from all reports was this incredibly impressive person. And I found the neighbours, the people who've been living in the house next door. They were now in Kibuye, which is this, beautiful part of Rwanda on Lake Kivu, looking across to Congo. And I went there and I sat with them and I met them, and they told me the story of what had happened on the 7th. that, you know, Inter Hanway had come, not in their hundreds, but had come to the compound and had killed this woman. And then my client, Mr. Gitete, came later and with the help of the family, put the body in the car and went to take it to get it cleaned and buried. So a different story from the prosecution case. And I remember when they were telling me this, that sitting there and this beautiful, and the sun came out sort of from behind this cloud and the lake went all sparkly. And I remember feeling sort of overwhelmed with, you know, truth and justice, and so happy that I was going to be able to, you know, bring this story to the tribunal and tell the judges. And I, you know, got my witness form to fill in their names. I'm like, I'm going to have to take photos of you. And they're like, oh, no, don't write our names down. You know, we can't be part of this case in any way. Please don't even mention that you've spoken with us to anybody. And I remember that on the drive back to Kigali feeling, you know, really dark, how you sometimes do in this job, knowing that what was going to happen in front of the ICTR wasn't going to be real. And of course, the prosecution witness, one witness actually uncorroborated, came and went, and Mr. Gitete was convicted and, you know, is still in prison for that, among other things. Is that a fair trial? Can Mr. Gitete bring witnesses in the same conditions as the prosecution? Are his rights being respected? Or are they being impinged because of the political pressure inside the country and the inability of the population to speak out in any way that goes against the official narrative that's been put in place? Or their inability to testify without the knowledge of their government? ICL is politically charged. You know, it has at its core the political will of states. We all know this. If the question is whether this reality impinges on the ability of the accused to enjoy their fair trial rights, I think the answer is yes. And all that we can do as defense counsel is defend our clients in the most professional and vigorous and determined way possible to try and mitigate the impact that politics has on these cases, which is more than enough from me. So I'm going to hand back to our moderator, Marion, but just to say that I really look forward to receiving any questions and to discussing these issues, which I obviously find fascinating, with you further in the panel.
Thank you very much, Kate. That was extremely interesting. This is such a deep dive in what being a member of a defense team is and our day-to-day challenges regarding investigations and meeting with witnesses, the simple possibility to meet with a witness. And that was extremely interesting. Thank you so much. Just in terms of organization, I would like to say two things. So Dominic asked me to inform you about the break rooms after the first panel. There will be 3 break rooms, one on coffee talk, which will be hosted by Danny, one on networking that will be hosted by Marie, and one on continuing with panel 1, which will be hosted by myself. And of course, if my panelists want to join, they are more than welcome. The second thing I would like to say is that if while going through the interventions from the panelists, you have questions and you want to communicate these questions to me directly so that I know that I can then give you the floor when the interventions will be over, please write in the chat, send me your question, and so that I can give you the floor directly after the interventions. So feel free to do that. And of course, if you have a question that arises after, you can still ask your question, of course. So now, I guess it is Stéphane, our next speaker. Stefan. Can you hear me? Yes.
Can you see me?
We can hear you and see you perfectly. So I give you the floor.
Okay, well, good morning, everyone. Great pleasure for me to participate in this panel. I think Dominic some time ago to address the influence of politics on the fairness of trials. And I see from Kate's presentation that the answer to the question is definitely yes. I'll try to bring to you the point of view of the practitioner, but practitioner both from as a member of ICTY, as more important, I had regular dealings with the Security Council members. And then, of course, my experience defense, both at ICTY and ICC. I'm not sure how well the connection is, a bit far away. I'm not sure.
Just Stefan, if I may, do you have another device like as a microphone? Because it seems that you would have a double microphone.
Can everyone hear me well?
And there is some lag, actually. So yes, Stefan, it seems that you have a double microphone. So if you could put one of them on mute, I think the problem is just there. Let's try it.
I will do my best. Maybe to. Okay. How's this now? Okay. So, as I was saying, I'll try to bring a point of view that cuts across my experience before ICTY, ICC, and MIC. Not to talk about also the Tribunal for Lebanon. I gave a lot of presentation over the years to various crowds. And most of the time I began my presentation by saying, what is the difference between what we do in The Hague and what happens in a domestic or domestic trial? And the difference in my view is twofold. The first difference is the size of the trials that we handle in The Hague. The size in terms of the number of charges, the size in terms of the number of events, the time period covered by the charges, actors involved. All this makes the trials we do in The Hague different. Not because there's not big trials domestically, but very rarely do you see a trial that will cover a 2-year period. And that makes a big difference. And the second difference between what we do in The Hague is, of course, the mix between law and politics. And also because, as Kate mentioned, and I will insist on that, everything we do on The Hague, in The Hague, whether it's ICC or ICTY, depends on state cooperation. And once you are dependent on state cooperation, well, the door is influenced. Just to pick up quickly from an example, Kate was saying about Rwanda and ICTR. Let me relate to you one quick example. I have to be careful because I'm walking on a thin line, but I recall the moment I was assigned as chef de cabinet for Claude Jourdan, the president of the ICTY. It had been only a week when I'd been assigned there. Word that due to the chamber had acquitted Barayaguiza with prejudice to the prosecution. Paul Kagame had made a speech and he basically said, well, if Wanda is no longer playing ball. So, of course, as chief of staff, I bring the matter to the president of the court. And I say, well, Monsieur le Président, you know, maybe we have a little problem here. I have to be careful again as what I say, but what I can say is that there was no problem and the case was reversed. And because there was no way that ICTY, ICTR, in fact, could proceed with the Rwandan state not playing ball. I was privy to everything that happened, leading to that it was a request by the offended. And to me, from that moment on, I understood how important and how critical what the states could do to influence the process. Now, let me go quickly with let's look at a difference between ICTY and everyone here who are who study these cases will remember the famous Tadic case. The Tadic case, one of the grounds of appeal that was brought before Judge Kasese was the fact that the creation of the ICTY created by a political body, namely the Security Council. Of course, that ground of appeal was dismissed. And Judge Kasese in his ruling said, it is not because a political body creates a court that the political body will then exercise influence over that court, because there can be separation of powers. It was a very sound legal argument, but there was a lot of critics, especially in the academic community. People were saying this is not right because we are opening the door for political influence. Well, now let's look at the same thing. And of course, if you look at ICTY, the only way that the Security Council could influence was maybe by refusing, for example, a request when we created the ad litem judges, or some lobbying in terms of the budget that would be given to the court, or again, by doing a preliminary assessment of those who wanted to be judges at the ICTY. Now, the input of the Security Council over the ICTY was, in my view, minimal, although it was there. Now, let's look at the ICC. All the academics were so happy. Oh, now we have a real court created as a treaty with real, something that is really international law and something that will work. Well, in my view, they creates a systemic problem for I see a message from Marion. I don't know what it says. Can you hear me, or?
I was trying to be discreet. No, we would like to suggest you to maybe cut the camera because we have some slight connection problems, and maybe by cutting off the camera, it would make the whole connection fluid. If it's okay with you, of course.
Okay, I will try that. So,
thank you.
Is that better? that better?
Yes, thank you.
Okay. So immediately at the preamble, and the preamble says that the aim of the court is to shows that the creators of the court, the state parties, what they want is to put an end to impunity. Well, that should not be the aim of a court, but I will not go on this. Then systemic problem is complementarity. Complementarity was you only go in if a state is unwilling or unable. You hear me? I see that everything is frozen.
For any reason I don't exactly understand, it seems that cutting off the camera made it worse. But just go on. We can follow you. I think that's the most important.
Let me try something else. I will, if I can go here, maybe it'll be better. I've been having internet problems for the past 2 weeks. I thought I'd solve it.
Weirdly, when you talk about your internet problems, it went away. It was very clear.
Okay. Oh, now I have this one, and I'll try to cut.
I think we lost him. Let me check. Yes, we temporarily lost him. Maybe what I suggest so that we can keep going is that Kairan, would you be ready to take the floor?
Absolutely, yeah.
Yeah, so, and it's interesting because Stefan gave a practitioner point of view, and you are going to give us an academic's point of view. So we can really say that academics and practitioner points of views will be intertwined, like literally. Thank you.
Thank you. Am I audible? Well, thank you, Marianne. First, I want to express my gratitude to the ADC-ICT, Dominic and the organizers for inviting me. It's quite an opportunity for me to listen and speak to such a distinguished array of panelists. So I'm hoping to provide an update on the developments that have been most important for universal jurisdiction proceedings in the last couple of years, and answer your questions by looking at the political and cyclical elements that may be relevant to understanding the status quo. I apologize if some of this is abstract, but I'm hoping that an update of this sort will still be useful and put further discussions in context. Now, before delving into the major recent proceedings themselves, I think it might be useful to reflect a little bit on the doctrine of universal jurisdiction. It could be argued that the progress of universal jurisdiction has been defined by cycles. In that, I mean, it has had periods of relative dormancy, at least in terms of profile, and phases of resurgence. And that understanding these cycles need a closer examination of various contexts, political and otherwise, of a non-judicial nature. This will surprise no one, as just the mere claim that there can exist a universal criminal jurisdiction, albeit for certain grave and selected crimes, is in itself one that evokes great political sensitivity and legal confusion. Now, Maximo Langer has identified certain factors that might affect or provoke a political reaction in the context of such proceedings. These include the profile of the defendants, the economic costs connected to the trials, and potential reaction from local political constituencies. If we take these together, perhaps unsurprisingly, it points to a reality that political considerations favor proceedings that are inexpensive. Expense here referring both to political and economic currency. a closer look perhaps at the Spanish experience over the last 3 decades, which has seen a marked change in the nature and the profile of the targeted defendants, point to both the cyclical ups and downs that have been faced by universal jurisdiction, as well as the impact of decisions of a non-judicial nature on the creation of these cycles. The 2014 decision by the Spanish Parliament that significantly diluted the provision of the nation's universal jurisdiction statute remains important in this context. What Langer also did was he surveyed around 1,050 universal jurisdiction related complaints that were received by public authorities in different nations. And he juxtaposed that with the numbers that went into trial and the nationality of the defendants. This revealed that in the case of 87 complaints brought against citizens of Rwanda, for example, 11 went on to the trial stage. In contrast of, let's say, 55 or 44 complaints that were brought against nationals of other nations, a grand total of 0 went on to the trial phase. On this note, it might be ideal to take a moment to reflect on the uniqueness of your universal jurisdiction as a doctrine that, on the one hand, is not dependent on the United Nations and multilateral frameworks for its existence, but on the other hand, needs to tread the delicate space between acting upon intangible and sometimes imaginary consensus that supposedly exists within the international community and state behavior that has the potential to be volatile based on international relations incentives. For this reason, any review of universal jurisdiction related developments that ignore the political components that revolve around it will most likely lead to incomplete conclusions. Now, none of this is to imply that what is being done today through universal jurisdiction proceedings is less important than what has been done before. It is merely to acknowledge that as we witness quite an extraordinary period in relation to such proceedings, acute political considerations will also play a major role in how this cycle will be judged. This is particularly pertinent due to the renewal of universal jurisdiction proceedings, partly due to more awareness, the establishment of specialized units within national prosecution and investigation agencies, and partly as a response to the existence of stalemates and resource-related issues in the international context. As for some of the proceedings that have been most relevant to the recent period, structural and focused investigations in Germany have led to multiple developments. Most notably, a judgment of the Higher Regional Court of Koblenz that was delivered in February 2021 convicted 2 Syrian officials belonging to the Assad regime's secret service of crimes against humanity, while another verdict from the Frankfurt Regional Court last week became the world's first verdict called that genocide was committed against the Yazidi people, while sentencing an Iraqi member of the Islamic State to life in prison. This prompted Nadia Murad, the Nobel Peace Prize laureate, to state that the German actions were, quote, not only raising awareness about the needs for justice, but also acting upon it, end quote. Another recent judgment from the German Federal Court of Justice dealing with the former officer of the Afghan National Army who was in German territory held that state officials do not enjoy functional immunity under international law in the case of international crimes. The judgment, while narrow in its construction, has been described as having the potential to be pioneering. Now, whether these proceedings will lead to the prosecution of higher officials, or whether they've reached a threshold that might invite political action, remains to be seen. Now, another major development saw the owner and chief executive of the Swedish company Lunden Energy being charged by Swedish prosecutors of complicity in grave war crimes committed in Sudan. The company officials have been charged with asking the Sudanese government to secure an oil field, despite understanding or allegedly choosing to be indifferent to the fact that such securing would have had to be done by force and in violation of international humanitarian law. Perhaps some of the following updates also reflect the distinctibility of universal jurisdiction to look backward and identify impunity gaps in relation to historical crimes and periods. This is a characteristic that may potentially allow universal jurisdiction to penetrate spaces and bring justice to issues that may escape the focus of international mechanisms due to time, resources, politics, and the complex wrangling that can tend to dilute international mandates. The Jesuits massacre trial that was held last year in Spain, in which an El Salvadoran colonel was convicted for his role in the murder of 6 Jesuit priests and 2 women in November 1989, as well as the recent indictment by an Argentine judge of Rodolfo Martin Villa, former minister of the Franco regime, showcases the possibilities of universal jurisdiction. The fact that the latter indictment was made despite a letter sent to the judge by 4 former Spanish prime ministers from across the political spectrum point to political factors that may play a role as the trial progresses. Moving on to non-judicial developments. In 2005, the Institute of International Law adopted a resolution on universal criminal jurisdiction with regards to the crime of genocide, crimes against humanity, and war crimes. The resolution contained the following excerpt that I'll just read out. The jurisdiction of states to prosecute crimes committed by non-nationals in the territory of another state must be governed by clear rules in order to ensure legal certainty and the reasonable exercise of that jurisdiction. Now that may seem self-evident, but the reality is that 15 years later, the 75th session of the United Nations General Assembly and the 76th session of the following year saw states expressing their frustration in relation to the lack of clarity as to what universal jurisdiction truly signifies. This clarity will also need to aid the understanding of how such proceedings are supposed to interact with international courts and the principle of subsidiarity. The 76th session saw submissions on the application and scope of universal jurisdiction made to the 6th committee by 16 states, the African Union, the Council of Europe, the International Organization of Migration, and the Organization for the Prohibition of Chemical Weapons. Reading these submissions again point to the same issues from years before continuing to persist, with states expressing their concerns on the lack of substantial progress after decades of discussion and continuing to hold vastly different views on this theme. Further concerns also exist in relation to the fact that such proceedings are only ostensibly targeting officials from specific regions as opposed to others. The bright note, though, is that more nations seem willing to remove obstacles and incorporate universal jurisdiction provisions into their domestic law. This led to the 76th session preparing a draft resolution recognizing the diversity of views that exist between the states and inviting a working group of the 6th committee to be established for next year's session. This group has been asked to consider the following question: what should be the role and the purpose of universal jurisdiction? In relation to this question, and also to conclude, Gary Simpson, in his book, Great Powers and Outlaw States, Unequal Sovereigns and an International Legal Order, describes the international legal order as a product of the interaction between 3 distinct languages: the language of sovereign equality, the language of great powers, and the language of anti-pluralism. In some way, these cycles of universal jurisdiction also interact with these languages. To some degree, perhaps, this lack of clarity may be a reflection of universal jurisdiction's intrinsic decentralized nature and of having to be universal in an unbalanced world. So as the United Nations continues to consider the role and purpose of universal jurisdiction, it can only be hoped that the proceedings and developments that are defining this important and ongoing cycle will confront more hierarchies, and even politically high-cost proceedings will both come into fruition and survive. Thank you.
Thank you very much, Karen. This was extremely interesting, especially because it's true that we always foresee international justice in international courts and tribunals, but we do not necessarily think about universal jurisdiction. And that's clearly a part of the picture. And thank you very much for reminding us and making like this brilliant and detailed presentation. I would like to...
Marion, I'm there.
Yes. I give you the floor for the rest of your presentation.
Thank you very much. I will conclude in no more than 5 minutes. I was talking about, of course, systemic problems.
Take your time, please. Take your time. We have the time.
Okay, systemic problems in the, of course, the statute of the ICC. And I mentioned a little earlier complementarity, but first we need to look at, after the preamble, of course, we look at the possibility for a state party to trigger a case or ask the prosecution to defer a case to the prosecution. I'm talking, of course, about Article 13A and 14 of the statute. Now, the case that the example that comes to mind is that of Congo. Congo, as in my view, played the court from the beginning by using Article 14 to get rid of its opponents, whereas many of the problems in Congo rested with the government and not with the opponents. Now, of course, that is not to say that crimes have not been committed. That's not the point of view. But by having the state trigger cases or ask the prosecution to investigate, then that investigation cannot take place unless they have the full support of the state, namely Congo, in order to maintain, secure this cooperation from Congo. The only way that this can be done is by playing with Congo. And of course, not going or doing anything against the will of Congo. And from a fairness point of view, these cases are always, as mentioned, opponents of the regime. And it is not possible for the defense to obtain the witnesses because the witnesses know that if they come to testify in The Hague for the defense, then for all intent and purposes, their life is over. They will lose their job, their families will lose their job, or they might even face some more serious consequences. Now, that's direct influence over the trial process. And of course, we look at I mentioned earlier, the Security Council. Power has been given to a political body, not to create a court like ICTY, but to directly influence the work of the court by either deferring a case or asking for the prosecution to conduct or investigate in a state which is a non-party to the ICC statute. Now, that is direct political power given to the Security Council. More importantly, we know that China, Russia, and the United States are not members, are not state parties. So here you have the 5 permanent members of the Security Council who rule and who decide on these cases. 3 of them are not state parties. To me, this is a fundamental problem which proves that there is political influence. If not, these 3 states would be in. Now, we look, that's one way of systemic problem, and the other one is the assembly of state parties. The assembly of state parties is much more powerful than by the looks of it. The assembly of state parties can really influence the work of the court because, as Kate was saying earlier, the assembly of state parties are there for impunity and they do not want acquittals. And they've made this clear, very clear in their input on the work of the court. Let me use an example. The Kenya cases. When there was, we remember that 2 of the accused in the Kenya cases became president and vice president of Kenya. One issue at the time was whether an accused should be present for his or her trial. And by lobbying the assembly of state parties, it became very clear that the Kenya, whether that was right or wrong is not the issue, but that Kenya was able to influence the work of the court and the adoption of rules regarding the presence of an accused by lobbying the floor at the assembly of state parties. Now, more recently, Kate mentioned the consequences of the Bemba acquittal, because everyone you speak to is saying, oh, the court might not have some fair trials. They say, what more do you want? Bemba was acquitted and Bagbo was acquitted. and the Kenya cases fail, I mean, what better example can you have of a fair court when all these cases fail? Well, these cases fail not because of fairness. These cases fail because everyone agrees they were not put together the right way by the office of the prosecutor. Now, once you have these cases and that you have so many acquittals, then the Assembly of State Parties decides that it wants no more acquittals. So what do? They call for an expert review of the court. And of course, the president accepted, probably reluctantly, but did accept to have an expert review of the court. Now, if you are a defense counsel or if you are an outside observer of the court, you imagine that the experts will come in and they will examine the court for the purpose of making the court work better. But the result, and the judges of the ICC are about to adopt new rules, the result is no. The result is the expert review leads to ensuring that there will be no acquittals. And this is what will happen for the next 10 years or so, as the judges turn around, as there is a turnaround of judges who come at the court. And fortunately, of course, the judges change regularly. And maybe we have a chance of getting around the present atmosphere, because it's been created by these acquittals. And now it is very difficult to have any case before this court leading to an acquittal or leading to a fair trial. That's my point of view from practicing before the ICC. That's my point of view from, for another example, trying to get one judge from the largest contributing country, Japan, a judge who actually, I have to be careful with the words I use, but made it very clearly to her fellow judges. You approved the fact that I became a diplomat at the same time as I was a judge, or I resign and you'll be forced to start over the Busco trial. Of course, what was the result? Of course, the judges said, no, it's okay. What the judge did was perfectly fine. And of course, the trial proceeded. That's just one more of the example where you have indirect political pressure being exercised on the judges, on the prosecution, and of course, the end result is trying for defense counsel to do their job, get witnesses, and be able to produce the evidence, which sometimes is not being made available. I could go on with many other examples. Disclosure is definitely one of the examples. And what I say about disclosure is that the idea of redacting all the information, of protecting all the information, there's a name behind that. And that's important to protect certain information. But before the ICC, it has reached such an extreme that this, caused by indirect political influence, is making the life or the possibility to have a fair trial very difficult, if not non-existent. So what is the solution? Well, it's nice to talk about a problem, but what's the solution? Well, the solution to me is the turning around of the judges and the training of the judges, and a lot for the academic community to look at those cases. It was the same at ICTY. You look at the judgment, it looks the best, but go further than just the appearance of the judgment, read between the lines, and it stands out that the fairness is not always there. So the solution to me is that's one of the solutions, but also I fear that the ICC will be marginalized in the future. The ICC is a body that is needed, and unless there is a serious realignment of the ICC towards making it a real court, then it will be marginalized. When the political powers don't know what to do with somebody, then they will feed that person to the ICC, and nothing else will happen. The ICC will continue to try to and put these persons under trial. I finished with the example of Congo and complementarity that I raised earlier on. What is the worst thing about this political influence, of course, going beyond the fairness of trials, is that the Congo government, by getting trials against its opponents and the prosecution being played, and by putting only these trials forward, well, now we go 20 years later in Congo, and the situation today is even worse than it was when the events leading to these cases took place. Not only is the situation worse, the people who are involved in these cases are the same ones who were not charged at the beginning, both from the government point of view and from other armed groups. So the ICC, which is supposed to put an end to impunity, well, look at Congo today. Did the ICC may accomplish its mission? Even if that mission is not the right mission for court, it failed miserably in my view, and Congo is a real example of this. So I would be much more inclined to favor regional courts where people understand the dynamics of the area. And the dynamics of the area, of course, you need an international component to these courts to preserve the fairness of trials. But that's a way to kind of protect trials from being influenced by governments or by the what Kate referred to, the political powers at play. Again, there would be many other examples I could give, but definitely it's an issue that is with us, that will remain. And to me, it's in the hands of the judges, and for the judges to realize that they are being played. Sometimes, not they, the judges, but the court is being played by certain provisions of the statute, and they have to be very, very careful with this, because it does have an impact on the fairness of trials. So that concludes my presentation. Thank you.
Thank you very much, Stéphane, for this very strong presentation, very determined, with extremely strong opinions. And of course, I encourage everyone in the audience to react if you have a reaction, to ask questions if you have questions, and I will gladly give you the floor. I have some questions for my panelists, and just before, I would like to react, because you both, Kate and Stéphane, spoke about this speech from the Japanese representative at the ASP in, I think it was in 2018. And I was also a member of a defense team who 1 month later benefited from an acquittal in the Gbagbo and Blegude case. And I can also concur to the frustration we felt when we heard this speech and when we read it. It was as if we felt we had contributed to undermine justice, where we think that we have taken a very direct part to fair trial, to the contrary. And I also believe that we did not really understand the content of the speech, and it remains a question mark for us, because we believe that acquittals are part of justice. They are a very clear and direct manifestation of justice. And so I can only concur to your surprise and the fact that we did not really understand what was happening at that time. Questions now. So this question is a global question and it is addressed to all of you. Do we know that for the purpose of transitional justice, accountability is a part of the process? Reconciliation is another part. There has been a ongoing questions before the ICTY of whether or not the ICTY was in charge of a reconciliation mission. Reconciliation is extremely political. Accountability is extremely judicial. So is it because we do not know whether reconciliation is a mission of international courts and tribunals that we still go under political pressure or political influence as you described them? And would it be a solution to separate strictly accountability and reconciliation, and to separate peace and justice? What do you think about that?
I'm happy to weigh in. It's a really interesting question, but I don't think that the ultimate goal should be the separation of reconciliation and justice. Ultimately, the purpose, one of the overriding purposes of meaningful criminal accountability is to try and bring communities back together. You know, communities that have been divided by periods of conflict or mass atrocities along whatever it was, ethnic lines, political lines, religious lines. The ultimate goal of criminal justice is that it contributes to a sustainable peace and to the reconciliation of a community. But we know and we see that that's only possible when the criminal justice process itself is not one-sided. Because when it is, it serves to exacerbate these divides rather than addressing them. Prosecuting one side of a conflict when there's been violence on both sides doesn't help and is actually harmful. So that's, I think, where we should focus rather than saying, let's put peace and reconciliation out of our minds. Because if we do, you know, what else are we doing here? The courts obviously have a very specific clinical mandate, which is to adjudicate cases, to determine in each case whether or not the prosecution has met its burden of proving each charge beyond a reasonable doubt. That's what it needs to do. But it does that in a larger framework, in a larger context that we can't be blind to. But what the international criminal courts have gotten wrong so far is not focusing on an even-handed pursuit of accountability, of prosecuting, you know, literally in the case of the ICTR, only one side. So if we keep doing that, there is no point to what we're doing because what we're doing is harmful. So we should keep in mind the bigger picture, but really focus on trying to circumvent the political pressures at play and help the communities come back together by an even-handed, you know, that's really idealistic for a Saturday morning. This is ideally what we should do. But I think we need to think idealistically and in these broad terms because what we're doing has a huge impact and is really important.
Thank you. Thank you very much, Kate. Anyone else want to react on that question?
Yes, if quick reaction. If you hear me?
Yes, you have the floor, Stefan.
Thank you. Many people would think, and I was a very strong believer in the prospect that without justice, there cannot be reconciliation. That was my point of view many years ago. That point of view has changed dramatically based on my experience, both before the ICTY, but mostly before the ICC. Because if I look at the ICC for the examples I mentioned earlier, Congo, there has been no reconciliation. And the situation is worse today than it was before the ICC stepped in through the Office of the Prosecutor at the request of Congo. So in some cases, in this situation, the first solution, in my view, is that when we speak of complementarity, and when a state is either unwilling or unable, the key to achieving both justice and reconciliation is for the Office of the Prosecutor in the first place to look and be able to look at all sides. If not, then there cannot be both reconciliation and justice. If that is not possible, then we are better off with a Truth and Reconciliation Commission, possibly leading to some cases. But by picking only some cases of some of the players, then you achieve no result in reconciliation, and the justice itself is challenged by influence of the government of that state. And that's, of course, a challenge for the ICC.
Thank you. Thank you very much, Stéphane. Kate, please.
Can I come back to something Stéphane said earlier, which I think is really interesting about what solutions would be, because sort of our want as defence counsel to rant and rave and complain, but it's nice sometimes to think about how things could be fixed. And I heard Stéphane say that sort of the regionalisation or the localisation of criminal justice could be a possible solution to removing politics from the criminal justice process, which I think is interesting. I've heard her Honour Christine van den Weingart speak about the fact that the ICTY was created to remove this incredibly politically charged question of criminal accountability out of the region. She called it this hot potato that they took out of the former Yugoslavia and put in The Hague, and sort of put it in neutral territory to avoid this political aspect. So she was saying sort of the opposite of what Stéphane was saying, and she was discussing it in the context of a debate of whether or not the ICTY had been successful in doing this, in taking this sort of political time bomb out of the region. Because that's the rationale, isn't it? That if you have these courts in The Hague or in Arusha or, you know, in Leichendam or wherever, then they can become these non-political institutions that sort of rise up above the divisions that are happening on the ground. I think that's nonsense. Put them wherever you want, you know, put these courts in the rainiest corner of Europe. That they don't exist in a vacuum. They rely on cooperation from states. You know, putting the ICTR in Arusha didn't remove it from Rwanda's political influence. Putting the ICTR in The Hague doesn't seal it off magically from political interference. But what it does do is remove the process from the affected communities and remove the process from the crime base and make it that every single witness, every victim witness has to travel internationally, which really increases the trauma as we see every day on the testifying process. And it breeds distrust locally. You know, who are these white judges in The Hague who are hearing these cases? It makes outreach harder, it makes understanding harder, it makes acceptance of accountability harder on the ground. And what does it really get us? Because we see it doesn't insulate us from political interference. And if you, just very quickly, if you look at the ECCC in Cambodia, which had a public gallery, a huge public gallery in Phnom Penh of 500 seats, and 160,000 Cambodians sat in that public gallery over the course of case 1 and 2 at the ECCC, and they watched the proceedings, and the journalists in Cambodia could all come and be present and be there, and it meant that the trials were, you know, on the front page of the papers, of the Phnom Penh Post, the Cambodia Daily. Everyone was talking about these trials, and the community felt involved, and they had an understanding, and they knew what was going on, and the acceptance of the ECCC as a tribunal was really, really high. as compared to the acceptance of the ICTY in the Balkans or the ICTY in Rwanda. Now, that doesn't mean that there wasn't political interference in Cambodia. There absolutely was. The Prime Minister Hun Sen basically dictated who could be tried. But if the ECCC had been in The Hague, it wouldn't have been able to avoid this political interference. So, is this a solution to try not to romanticize the physical removal of these international courts away from the regions themselves? Was what I wanted to say.
Yes, thank you very much. Thank you very much, Kate, and thank you very much for anticipating on my next question. But I see Judge Corner, I'm giving you the floor.
It's jolly kind of you because I'm not on this panel, but obviously I was fascinated to listen to this. And I really do want to come back on two things because I think it's really important. Firstly, and because Kate's point about the trial, the ICTY trials being in The Hague and not in the former Yugoslavia. I don't know whether Kate remembers, but I certainly do, what the atmosphere was like in Bosnia, Croatia, and mainly in those two countries, and of course Serbia. It would have been absolutely impossible to hold trials, to get the witnesses there in the circumstances that prevailed, the aftermath of the conflict, which is still going on, as we can all see from what Dodik is doing, would have made it impossible. Witnesses wouldn't have come to court. So appreciating all, and I'm not in any sense trying to detract from any political influence that everybody's been talking about. But there was a real and practical reason for that as far as Yugoslavia was concerned. Second, can I get back to Stefan's point about the expert review and his assertion that it is designed entirely to prevent any further acquittals taking place at the ICC. It is designed, and we, the trial judges, are putting into effect to make the procedures fairer because they are more consistent, so that all trial chambers have the same method of admission, for example, or submission, whichever you choose, of documents. It is looked at all aspects of the court in order to try, as I say, to bring some kind of consistency, not to stop acquittals, but so that when there are acquittals, as there undoubtedly will be, because I agree that an acquittal is the sign of a proper and fair justice system, they will not be acquittals which are, as many of the academic commentators have said, difficult to understand and creating difficulties in the application of law. So you won't be surprised to hear that I strongly disagree with Stefan on that. So thank you very much for giving me the floor.
Thank you very much, Judge Corner. Actually, I was hoping that you would take the floor because I anticipated that you would disagree, and it was extremely important to have your point of view and your reaction. Thank you very much. Stefan, do you want to reply maybe?
Yes,
you want
absolutely,
to seek leave
absolutely.
to reply?
I've known Judge Corner for a long time, and I have the utmost of respect for Judge Corner, and I agree with what she said. Of course, Judge, you mentioned my assertion that it was designed for the purpose of what I wanted to say, and maybe it's the English language. It's not an assertion that it was designed to ensure that there will be no more acquittal. I said the aim of the expert review, the manner, the reason why it was launched, it was requested, it was as a reaction to the number of acquittals. That's what I meant to say. Now, once it was triggered, of course, I would have liked if the experts would have given more time to listening to what the practitioners had to say. For my part, I know that the defense at the ICC, we had a session of 1 hour planned with 3 of the experts, and in the end, it turned out to be a 15-minute session, and that was it. Of course, we could have put in writing our observations, and it was open to us to do that. But when you are conducting and you are in the middle of a trial, it's very difficult to take the time and to write a paper. And I would have liked to have more time with the experts to explain to them the point of view of the of why this what needed to be reviewed at the court. Because you mentioned, Judge, the issue of consistency, and that is, in my view, one of the most important issues, in that the manner in which trials are conducted from one trial chamber to the next is not the same. But this is not new. At ICTY, there were some changes from one trial chamber to the other. But at the ICC, it seems to be much more pronounced in terms of how judges are allowed in each of their chamber. The deference given to the trial chamber appears to be much more, and there are significant differences. If by having the expert review leading to more consistency, I could not agree more, Judge. This is definitely what is needed, so that there is an expectation of what you will have in a trial. And of course, my comments might appear a bit strong, but at the same time, when I look at the case I was in, a case that lasted for so many years, and it appeared to be that this was the case where the prosecution was trying everything new because they knew that the judges would go their way. And many of the changes that were brought to how to run a trial, there was a marked departure in the case I was involved in from previous practice. And that, of course, made our life difficult, and in my view, affected the fairness of the trial. Even though there was an appellate review, and I have to say that now I have nothing more, I have no further avenue to look at the fairness of the trial I was involved in, but it continues to haunt me, and that was never the case before. I always thought in my legal career that once the appeals chamber has spoken, this is it, and you live with the result. But now in this case, I must say that I have very much a lot of difficulty living with the result of that trial, which I think is because there had been acquittals before, and I believe that Mr. Taganda was never given a fair chance before this court.
Thank you, Stéphane. Judge Corner, if you want to reply, please.
No, I understand Stéphane's point on Ntaganda, but I don't think there's any. I just wanted to make sure that everybody understood, and Stéphane's corrected it. I cannot comment on what he says the aim of the expert review was. As I think everybody knows, I've only been here a few months. But what I wanted to get across was that what it certainly in terms of trials, its aims should be seen as laudable by all sides.
Thank you very much for your intervention. Thank you to all of you. It is now 11 a.m. so I guess we have to move to the break rooms. Dominic will confirm whether I am correct or not. Oh, sorry, we have one person who wants to react, and so it's Cecilia. So Cecilia, please, I think we can take a few minutes to a few more minutes. Please, Cecilia, you have the floor.
Thank you very much, Marion. Thank you everyone for this fascinating interventions. It was really, yes, brightening my morning. I just wanted to highlight a very specific point that I think also deserves attention. We have spoken about the impact of political interference on the rights of the accused, which is essential, of course, but I think there is another aspect that is interesting. It's how also political interference allows the ICC and international tribunals to fail victims of the crimes that aren't politically convenient to prosecute. And the case that I'm most familiar with on my end is that of Syria, which is not at the moment prosecuted before international courts and tribunals, but may very well be in the future. And we have seen from the outstart the disproportionate amount of attention paid to the crimes committed by the Syrian government. And as a result, leaving aside thousands of victims of other alleged perpetrators, and creating a really a significant gap in the justice outcome. So I think when we talk about political interference and the fair trial, yes, the right of the accused is paramount, but there is also the right of the victims that can also be impacted negatively by this kind of political interference. So that's just what I wanted to highlight. And thank you very much, everyone, for your interference, your interventions today.
Thank you very much, Cecilia. Maybe one of our panelists would like to react to your statement about the fact that the rights of the victims could also be affected by political interference. Kate.
Yes. The interference of states doesn't just impact on the rights of the accused to a fair trial, which was the point of this morning's panel. It absolutely impacts on all aspects of the justice process. Very strong, strident language coming out in response to Karim Khan's decision to deprioritize and prioritize certain aspects of the Afghanistan situation that civil society decried as being the influence of politics, pragmatism, covering for political interference, and that this was letting down victims of powerful states who have somehow managed to work their way in. Amnesty International came out and said that decision is unfathomable and should be reconsidered, which is not the view held by everyone. Some people were applauding his stance and saying that the decision that he's taken is a reasonable one, because then at least some trials or investigations will proceed. So, regardless of the community that you're speaking from or the angle that you're approaching this from, the influence of politics is impossible to divorce from international crimes. That's where we are. And, Judge Corner is exactly right that in the early days of the ICTY, although I don't remember them, but it wasn't possible for Yugoslavian victims, witnesses, perpetrators to walk into courtrooms on the ground. The situation was way too politically charged. The point that I think we've made today is that, are we right to say that simply by removing these courts from the affected communities and putting them somewhere else, that we seal ourselves off from any sort of political interference, which was the question that Judge Van den Weingart had at the time, and one that I don't think is realistic, because we see every day in our work as practitioners in front of these courts that political interference weighs in on many different levels. And that is despite the professionalism of defense counsel, professionalism of legal representatives of victims, professionalism on the part of members of the bench, professionalism on the part of the prosecution. At its core, we are an area of international criminal justice that relies on the political whim of states. And the more that we're alive to that, I think the better. The more that we can have discussions like today's, I think the better. And we can try and find ways to bravely mitigate the impact of politics on the work that we do, which is at its core really important.
Thank you very much, Kate. Yes, I will now invite you to move to the to the break room. Sorry, I would not like. I don't want to be seen as advertising for my break room, but I still have questions for our panelists. By the way, I have a message for Chiara Loiero, if she's still here. Yes, she is. Chiara, you tweeted yesterday a report from Amnesty International. I think it was you. If you want to come to the break room and bring this report to the discussion, I think it is very relevant to the budget of defense teams, to the means given to defense teams to help in the process of justice. As a conclusion, I would like to thank you all for attending this first panel. It was really great to have you. Thank you for the questions. Thank you for the reactions. And maybe I will give the floor to Dominic or to Marie to check how we can move to the break rooms. Dominic? Marie? Dominic?
Yep, good morning, everybody. Oh, Marie's there. Yep, you can just join the break rooms at the bottom. You should be able to see that there's 3 rooms. And if you click on them, you should be able to enter them until 11:30 when the next panel is due to commence.